Bonjour à toutes.
Good day, everyone. We are now going to call the meeting to order, which is meeting 23 of the House of Commons Standing Committee on Public Safety and National Security. Pursuant to the order of reference from the House on October 3rd, 2025, we are meeting today to study Bill C-8, an act respecting cybersecurity, amending the Telecommunications Act, and making related amendments to other acts. I would now like to welcome our witnesses, whom we know very well, and who will answer questions as necessary. From the Department of Public Safety and Emergency Preparedness, Colin McSween and Kelly Ann Gibson, and from the Department of Industry, Andre Arbor and Wen Kwan. We also have other public servants in the room who will be able to take a seat at the table if needed. We will now move on to clause-by-clause consideration of the bill. You will probably recall that last time we were considering Amendment CPC 19, and that is therefore where we are taking the study back up today. Does anyone wish to propose Amendment CPC 19? We can take a few moments to give committee members time to find this amendment. Again, it is CPC 19. And the notice of tabling has been submitted.
CPC 19. I intend to move CPC 21 instead.
Good. So we will not be tabling CPC 19 or moving CPC 19, which brings us to another amendment, which is CPC 20. Is CPC 20 being moved?
Yes, Mr. Chair, I'd like to move CPC 20, please.
Very good. Would you like to speak to it?
Not at this point.
No?
I think we've done a fair amount of talking. I think we know generally where the lines have been drawn, and I'll leave it to you. And if there are other interventions, I'm happy to respond.
Very good. So any discussion on CPC 20? Ms. MP Ramsey?
Yes, I would like to ask Mr. Arbor why I feel that this amendment would strongly reduce the power of to collect information. So I'd like to verify with Mr. Arbor if he's of that opinion.
Thank you, Mr. Chair, for the question. The concerns with respect to this amendment concern this switch from collecting information that is relevant to an order-making activity to necessary. And then there's also a lack of clarity, potentially, and some risk of confusion. But the core issue appears to be the difference between necessary and relevance. The issue here is that there is information that is highly relevant to an order-making activity that it's highly debatable whether it would be necessary. For example, information from the private sector on the costs of implementing an order to undertake a reasonable cost-benefit analysis of how to calibrate the order, for instance. Arguably, that is not, strictly speaking, necessary to proceed, but it is certainly relevant to whether and how an order should be calibrated. The issue that the risk of lack of precision is due to the language around gravity of the threat. Another reason for collecting information in this context would be to verify compliance. Taking the gravity of the threat language out of the order making and putting it into the information collection, it's unclear what threat we're talking about here. Is it the threat of noncompliance? Is it the threat for the reason of the order to begin with? But I'll stop there, and hopefully that's clear, but happy to go further as needed.
MP Caputo?
Yes, thank you, and I thank the officials, and I welcome them back. It's our third day, and I know that they've got a lot on their plate, so we are very grateful for their presence here. One of the reasons I will be voting in favor of this motion, given the foregoing, is when we do have ambiguity, where it's like, well, this may be necessary. I think that's part of the issue. That people and Canadians write to me is when there is ambiguity, when there is concern, because something may not be necessary. If it may not be necessary, it may be necessary. So any clarification that we can give is something that I believe should animate our discussions and animate our votes, and is for that reason that I will be voting for this amendment. Thank you.
Thank you, Mr. Caputo. Anyone else? In which case, we would be moving to asking whether CPC 20 is adopted. We will proceed with a roll call vote. Mr. Clerk?
Thank you, Mr. Chair. The vote is on CPC Amendment number 20. Mr. Ramsey?
Contre.
Mr. Danko?
Nay.
Mr. Pawlowski?
No.
Ms. Auguste?
Contre.
Mr. Caputo?
In favor.
Mr. Lloyd?
In favor.
Ms. Kirkland?
Yes.
Mr. Au?
Yes.
Madame de Bellefeuille?
Pour.
Yeas pour 5, nays contre 4.
Merci, Monsieur le greffier.
Thank you, Chair. The amendment is therefore carried, which now brings us to amendment which is deemed to be tabled. It is amendment NPDP 5. Ms. Kwan, would you like to take the floor?
Thank you very much, Mr. Chair. NDP 5, the rationale behind this amendment, Mr. Chair, is that Bill C-8 grants the minister broad powers to compel the production of any information considered on reasonable grounds to be relevant to the exercise or enforcement of the minister's powers under Part 1 of the bill. This could allow the government to order companies to hand over the personal and confidential data of Canadians without a judicial warrant or other independent oversight. As the Canadian Civil Liberties Association has pointed out, amongst others, this, quote, falls short of the constitutional minimum, end quote. This amendment requires the government to obtain prior judicial authorization from the federal court before it can compel a telecommunications provider to disclose personal or de-identified information, so that this section of Bill C-8 can meet the minimum protection against the government interfering with individuals' reasonable expectation of privacy under Section 8 of the Charter. Mr. Chair, I would note that this amendment is identical to CPC 21.
Merci, Madame la députée.
Thank you, Ms. Kwan. And so Bill C-8, which amends the Telecommunications Act to enable the minister under Section 15.4 to order that information be provided to the department that the minister deems relevant to establish or check whether an order has been respected under Sections 15.1 and 15.2. The amendment would require the minister to obtain authorization of a judge to proceed to such an order in certain circumstances. So in the Book on Procedure of the House of Commons, 4th edition, Section 16.74, it is written, an amendment to a bill referred to committee after second reading is out of order if it exceeds the scope and the principle, and the chair is of the opinion that introducing advance judge authorization does exceed the scope of the bill. Therefore, I declare this amendment out of order. Mr. Caputo.
The greatest of respect, Chair, I would challenge your decision, please.
Thank you, Mr. Caputo, which brings us to an immediate vote. Mr. Clerk, would you like please to proceed to a roll call vote?
Thank you, Mr. Chair. The motion is, shall the ruling of the chair on NDP Amendment 5 be sustained? Mr. Ramsey?
In favor of the ruling by the President.
Mr. Danko?
Yay.
Mr. Pawlowski?
Sustain.
Ms. Auguste?
Oui.
Mr. Caputo?
No.
Mr. Lloyd?
No.
Madam Kirkland?
No.
Mr. Au?
No.
Madame de Bellefeuille? Yeas pour 4, nays contre 5.
Merci, Monsieur.
Thank you, Mr. Clerk. Which brings us to debate this amendment. Are there any interventions? Ms. de Bellefeuille, Mr. Ramsey, and Mr. Caputo. I have a clarification question, Chair. Your decision was challenged and defeated, but you said that this amendment was out of order. To my mind, there was CBC 21 and NDP 5 that were similar, but right out the gate, you did not specify that there was a line conflict. So to your mind, are these two different amendments? Excellent question. They are very similar, but they are not identical. They are not identical word for word.
Monsieur.
Mr. Ramsey. I would like to remind everyone that in sections 2, 3, 4, the word person refers just as much to a person as to a telecommunications service provider company. So this section would also make it impossible to collect information from telecommunications companies. Now, I would have two questions for the panel. First, if I'm understanding, this amendment would be out of step with the existing regulatory regimes in a number of sectors. I would like to hear our experts speak to that. Second, in your opinion, would there be other approaches, other amendments that have been proposed that would better fulfill this role than NDP 5? Thank you.
Merci.
Thank you, Mr. Chair, for the question.
Oui, la provision.
Yes. The provision that currently exists in Bill C-8 was drafted basing ourselves on the Telecommunications Act, which has been in effect since the 1970s, so several decades, and it is very similar. There's another provision in the Broadcasting Act. Once again, it is very similar. And there are a number of provisions in the Insurance Act, in the banking context, and the health context, and drug regulation, for example, in the transportation sector. Information request for the private sector when it comes to this context is very, very important for the regulations to be targeted towards the implementation and operation of networks in the public sector. So, without having that type of provision, Part 1 might not be useful. The proposal of having a judge intervene does not exist up until the present in the federal context. That is entirely new. And the proposal introduces the context of charter rights, but for businesses, because relevant information is information from businesses, financial or operating entities. These are, or rather, these are not. These exist in the Telecommunications Act and the Broadcasting Act, and have done for decades. Another point of clarification: we're indicating the concept of a person, but once again, I believe there is confusion between the term person, as we use it in daily language, and the word in a legal context. So in a law such as the Telecommunications Act, the term person refers to a legal person, which means a corporation. So yes, for this provision, it would be just about impossible to fulfill Part 1 effectively, given the evolution of technology, which is under a changing regulatory landscape. The committee has already carried the authorization process, which might add months or even years to the process for an order with this proposal. And perhaps for every business, the amount of paperwork and the difficulty to fulfill that proposal would be extremely difficult. And one last point, perhaps. Yes, of course, there are other proposals, including BQ6 and BQ7, which, in my opinion, are much more specific on the matter of protection of personal information, rather than the protection of information for Bell or Rogers, which would prevent the government from being able to share that. Thank you.
Excellent. D'autres
Excellent. Any other comments? Which now brings us to the vote.
Nous allons procéder par
We will have a recorded division. Mr. Clerk, interpretation will resume after the vote.
Les votes sur l'amendement numéro 5 de l'NPD. Et
Contre.
Mr. Danko.
Nay.
Mr. Pawlowski.
Against.
Madame Auguste.
Contre.
Mr. Caputo.
In favor.
Mr. Lloyd.
In favor.
Ms. Kirkland.
Yes.
Mr. Au.
Yes.
Madame de Bellefeuille.
Contre.
Yeas pour 4, nays contre 5.
Yeas 4, nays 5. Thank you, Mr. Clerk. The amendment is therefore defeated. As it was mentioned earlier, Amendment CPC 21 is very similar to Amendment NDP 5, but it is not identical, and that is why it is in order and it can be debated. But before we move to debate, does anyone wish to table it and propose this amendment? CPC 21.
Yes. Well, I will move CPC 21, and I imagine we will go straight to a vote. Thank you.
Not immediately, because this is the same This is going to lead the same decision that I just made for the previous amendment. Et la décision est une décision d'irrecevabilité.
So this is a decision of whether or not this is in order. I could read the reasons again, but so this amendment would make it necessary for the department to get an order from a judge in certain circumstances, and in the chair's opinion, this exceeds the scope and principle of the bill, which means that the chair finds that this is a new concept and does exceed the scope and principle of the bill, and therefore is out of order.
With the greatest respect, I will again challenge the chair. Thank you.
Ce qui nous amène à un vote immédiat.
Which leads us to an immediate vote. Please go ahead, Mr. Clerk.
Président, the question is, shall the ruling of the chair on CPC Amendment 21 be sustained? Mr. Ramsey.
4, oui.
Mr. Danko.
Yay.
Mr. Pawlowski.
Sustain.
Madame Auguste.
Oui.
Mr. Caputo.
No.
Mr. Lloyd. Nay. Ms. Kirkland.
No.
Mr. Au.
No.
Madame de Bellefeuille.
Pour.
Yeas pour 5, nays contre 4.
Merci, Monsieur le greffier.
Thank you, Mr. Clerk. The chair's decision is therefore upheld. And we will now move on to Amendment NDP 6, which is deemed to have been proposed. Ms. Kwan, would you like to speak to this amendment?
Mr. Chair. Presently, the limits on sharing personal information obtained through Section 15.4 are contingent on whether a telecommunications service provider has chosen to designate its customers' personal information as confidential. This amendment, 1, will deem personal and de-identified information that is not designated as confidential by a telecommunications provider as confidential, and 2, would introduce data retention and deletion clauses so that confidential information is retained only for as long as it is necessary. And Mr. Chair, this amendment is similar to Block 5 and Block 7 and PV 6 as well.
Merci, Madame la députée. Des interventions sur NDP 6?
Thank you. Any comments on this amendment? This will lead us to take a decision. Is NDP 6 carried?
Non. Alors, je constate que l'amendement NDP 6 est...
I observe that this amendment is defeated on division. Amendment BQ5 can only be moved if NDP 6 was defeated, which it was, which therefore brings us to BQ5. Is BQ5 moved?
Je dépose.
Yes, Mr. Chair, I move BQ5. And Ms. Kwan's explanations were very relevant, but we have formulated our wording differently in BQ5. So BQ5 is directly a recommendation for the Privacy Commissioner. The Commissioner made a few recommendations and led us to propose some amendments in the Bloc Québécois. So this would be to amend the clause. Thank you, Ms. de Bellefeuille. Any comments? Mr. Ramsey. This amendment adds additional complexity to the Act. However, we have reached the conclusion that that complexity can ensure that the government will treat private information with the appropriate confidentiality, and therefore we will vote in favor.
Merci, Monsieur le député.
Thank you, Mr. Ramsey. Other comments?
BQ5 est...
Is BQ5 moved? Carried, rather. BQ5 is carried on division. Now let's go to PV6, which is deemed to have been moved. Ms. Kwan. Oh, my mistakes. The Green Party. That's just a small mistake. It's PV. It's strange, n'est-ce pas? Isn't it, rather? We have to participate in this way.
We had a problem
with that lettering because the G would have been the same as G for government. So that's why we use the French, a Green Party. So I will kick it off for PV6.
Clear, and they're not far from some of the points that Jenny was making earlier, that we're trying to find ways to protect privacy. So the sections, all of section 15.5 is described as sections that relate to confidential information and their designation. So the amendment that we're putting forward would be to ensure that people's privacy cannot be violated at the discretion of service providers. I think the language is pretty clear, and it's a short amendment. You have it in front of you, and I would please urge you to consider accepting it as an amendment to this bill. Thank you.
Thank you, Madame May. Madame de Bellefeuille?
Ms. de Bellefeuille. Point of clarification. I see that BQ5, which was carried, and PV6 are almost identical. So is it germane? I don't know. Since we've already carried the block amendment, I don't know if the legislative clerk might be able to clarify that. Yes, but I can also tell you it's a question of redundancy. The objective is very similar, if not identical, but the wording is different. So this is an amendment that is in order. But if ever it were to be carried, since we already carried BQ5, it would create a redundancy, and the legislative clerk and the legal experts from the department would have to arbitrate and vote on two very similar amendments. And it would be up to the departmental experts and the House of Commons experts to take a decision on behalf of the committee, given that there would be redundancy between those two amendments. Thank you. Mr. Ramsey.
Madame de Bellefeuille, we consider it to be so similar to BQ5 that we don't think PV6 is necessary. We're going to vote against.
Merci, Monsieur le député Ramsey. D'autres interventions?
Thank you, Mr. Ramsey. Are there other comments? Amendment PV6. Is this amendment carried?
Je crois qu'il est rejeté.
I believe it is defeated on division.
Alors, ce qui va nous amener.
Which brings us to Amendment BQ6.
Est-ce que Madame de Bellefeuille?
Ms. de Bellefeuille, would you like to intervene on BQ6? Yes. So once again, Amendment BQ6 would make it possible to add new restrictions on the information that could be collected. And once again, this specificity was inspired for us by the witness from the Privacy Commissioner's office. So I would encourage my colleagues to respect that recommendation by that expert, which seemed very wise given the circumstances.
Merci, Madame.
Thank you, Ms. de Bellefeuille.
Une intervention, des interventions?
Any comments on BQ6? If not, we will ask the question, is BQ6 carried?
L'amendement BQ6 est adopté.
Amendment BQ6 is carried on division. We now move to Amendment PV7, which is deemed to have been moved. Ms. May.
Monsieur.
Mr. Chair, I think that for Amendment PV7, it is very close to the Bloc Québécois amendment, which we already voted to carry on Ms. de Bellefeuille's amendment. So I think with the clerks, the legislative clerks' confirmation. I think my amendment is, in fact, too close to the one we already carried.
Merci, Madame.
Thank you, Ms. May. So if PV 7 were to be carried, the amendments.
Que j'étais distrait là. Bon. C'est ce qui se passe lorsqu'on écoute deux personnes en même temps. Donc, Madame May, vous ne déposez pas votre, vous ne proposez pas votre.
So, Ms. May, you are not tabling your amendment? On the topic of PV 7, I don't have any power here to make the decision. I don't have the power to propose or reject my amendments.
That my amendments I can neither move them, nor can I ask for them to be withdrawn on my motion. So I'm in your hands. I point out the reality, and I can't vote or withdraw or comment on my amendments beyond the brief time allowed in the motion that this committee passed.
That is correct, Madame May. Your expertise and your experience show again. So that amendment, having been moved by default, means that we cannot withdraw it unless there is unanimous consent to doing so. Mr. Caputo?
Yes, I'll seek unanimous consent to withdraw. Thank you.
Est-ce qu'il y a consentement unanime pour le retirer?
Is there unanimous consent to withdraw? Thank you very much, Ms. May, for helping us to move smoothly along. So amendment PV7 is withdrawn, which brings us to amendment CPC 22. Is CPC 22 moved?
No, I will not be moving that. Thank you.
Très bien. Donc, l'amendement, c'est.
Very well. CPC 22 is not moved, which brings us to amendment NDP 7. Is NDP 7, or rather, NDP 7 is deemed to have been moved. Ms. Kwan.
Mr. Chair, this amendment, it's about the collection and disclosure of personal information under the bill, which is not presently limited by necessity or proportionality requirements. So this amendment proposes to include the following in subsection 15.54C to balance the disclosure of sensitive information with the gravity of the threat to Canadian telecommunications system. I won't read the clause into the language, Mr. Chair. That clause is available to all members in both languages.
Merci, Madame la députée.
Thank you, Ms. Kwan. Are there any comments?
Monsieur le député Caputo?
Mr. Caputo.
Thank you very much, Mr. Chair. I wonder if my colleague would consent to an amendment that would amend Part C to read, quote, the minister believes on reasonable grounds that the disclosure is reasonable in relation to the gravity of the threat and necessary to secure the Canadian telecommunications system.
We can pause for a moment, Madame Kwan, if that is useful before you, well, we'll pause for a moment, we'll suspend, and we'll come back in a couple of minutes.
That's fine.
Nous sommes maintenant en mesure de recommencer. Il y a eu un peu de confusion, comme vous le savez.
We're now able to resume. As you know, there was some confusion. We are now going to discuss amendment deemed moved, NDP 7. Mr. Caputo.
Thank you, Mr. Chair. The parties have discussed this. I think that the most prudent maneuver would be that we seek to withdraw NDP 7, and we would need UC for that, and we would also need UC for me to move CPC 22 to eventually accomplish what we're trying to accomplish with the amendment.
Okay. Alors, est-ce qu'il y a consentement unanime pour...
So is there unanimous consent to withdraw NDP 7?
Je ne crois pas qu'il y a consentement.
I don't believe there is unanimous consent.
Alors, ce qui nous amène...
Which brings us to come back to NDP 7. Are there any interventions, any comments on NDP 7? Ms. de Bellefeuille. I would just like to hear our witnesses on this amendment, which I'm going to vote in favor of. I would still like to hear you. Do you have any hesitations about it? Because it seemed very wise in my view. Could you speak to that? And just before you get started, Mr. Arbour, I would also like to highlight that before the break, Mr. Chair, we had the break to wait for a sub-amendment to be translated. And I would like for you to confirm something. This is more of a point of order. Has this sub-amendment been withdrawn because there was a problem with the Translation Bureau? Because our wait times are longer because the Bureau does not have the capacity to provide a sub-amendment translation quickly? What went on during all of that time that we were waiting? I would like you to inform us. I find that deeply concerning. Very well. I will answer your question first. And if I'm understanding, the analysts will answer a different question. So I can reassure you, of course, it always takes a bit of time to complete a translation, but the translation was not the issue here. It was the coherence between the sub-amendment and the amendment itself. And we believed, when I say we, I mean the legislative clerks, at first look, because the sub-amendment was done quickly, they thought that it was compatible with the amendment, and they sent it for translation. And then at a different point in time, we realized that the sub-amendment was not actually aligned with the amendment. So that is the reason why the sub-amendment is not being debated currently, and that's why we are instead debating NDP 7. Would you like to take the floor?
Merci, Monsieur le...
Thank you, Mr. Chair, for the question. In regards to both CPC 22 and NDP 7, but I understand the question is regarding CPC 22. The wording is very, very similar in the current wording. So it wouldn't be very important to have a change to achieve our goals. The criteria for the communication of confidential information is slightly more strict than the current text, but it's not a big difference. And I might add that in this context, when we're talking about information in the private sector, usually, in my career experience, it has been members of parliament and civil society who tend to want access to that type of information. And there might be questions put to public servants. What is the reason why the government is not communicating that information in the interest of transparency? So that is just a small comment on that decision, but in the general context, the difference is very slight.
Merci. D'autres?
Thank you. Any other comments? That brings us to the question, is NDP 7 carried? NDP 7 is carried. Carried on division.
Écoutez, on va procéder par...
In fact, we'll have a recorded vote. Is NDP 7 carried? Mr. Clerk, please carry out the vote.
Merci beaucoup, Monsieur le Président. La vote.
Thank you very much, Mr. Chair. The question is on Amendment NDP 7.
Mr. Danko.
Yay.
For.
Pour.
No.
Mr. Lloyd.
Contra.
Ms. Kirkland.
No.
Mr. Au.
No.
Madame de Bellefeuille.
Pour.
Yeas pour 5, nays contre 4.
Merci, Monsieur le greffier.
Thank you, Mr. Clerk. Amendment NDP 7 is therefore carried, which brings us to CPC 23. Is CPC 23 moved?
Thank you. I will move CPC 23, please.
Thank you, Mr. Caputo. Anyone on CPC 23? Is CPC 23 adopted? That is,
No.
no, okay. Okay, CBC. I see the room and believe that it's rejected on dissidence, on division. Which brings us to CPC 24. Is CPC 24 moved? No. CPC 24 is therefore not moved. Bringing us to NDP 8, which is deemed moved. Madame Kwan.
Thank you very much, Mr. Chair, and I want to thank committee members for passing my last amendment. On this one, Section 15.54B allows for the disclosure of confidential information with the consent of the person who designated the information as confidential. Telecommunications providers should not be able to, quote, consent on behalf of their customers to the sharing of personal or de-identified information. The amendment therefore ensures clearer limits on the sharing of personal information by requiring that consent be obtained from the person to whom the information relates rather than a third party before that information can be disclosed to other government agencies.
Merci, Madame la députée Kwan. Puisque
Thank you, Ms. Kwan. Given that NDP 8 has been moved, CPC 25 cannot be moved because the two amendments are identical. So CPC 25 being identical to NDP 8 cannot be moved. We will now debate NDP 8. Are there any comments?
non. Est-ce que
Seeing none, is NDP 8 carried? Carried on division. Which brings us to CPC 26. Is CPC 26 moved?
so CPC 26 is moved? Any intervention on CPC 26? MP Ramsey?
Yes, we are against this amendment. On pense que ça va limiter.
We feel that it will severely limit the possibility to intervene in legal contexts, and this could lead to risks for telecommunications. The objective of the Act is to minimize risks for telecommunications. It is not to determine whether or not something is legal. So when it comes to the risk for the telecommunications system, legal behavior, when it comes to networks that could be negligent or deficient, and they are not illegal, but it is dangerous for the system, the telecommunications system. So I would like for our expert, Mr. Arbour, to comment.
Merci, Monsieur le Président.
Thank you, Mr. Chair, for the question.
Oui, bien sûr, cette proposition
Of course, this proposal would create serious problems with this bill. There are quite a number of activities when it comes to operation of networks, such as the frequency of software updates or the type of equipment used for the network. Those practices are not illegal in the terms of the criminal code, but of course they are a risk for the security of our infrastructure. That's very important. For example, in 2022, we observed a difficulty at Rogers. For operating of telecommunications networks for Canadians. So there would be enormous risks were this amendment to be carried.
Merci, Monsieur le député.
Thank you, Mr. Ramsey. Other comments? Is CPC 26 carried?
Rejeté avec.
Defeated on division. Let's move now to PV 8, which is deemed moved. Ms. May?
Merci, Monsieur le Président.
Thank you, Mr. Chair. This is very clear and simple.
If you're looking at subsection 15.6.1, you'll see that it just is a straightforward that despite section 15.5, to the extent that is necessary for any purpose, and based on the evidence of a number of witnesses, we're changing that instead of saying is necessary, that they believe on reasonable grounds is necessary. So it's another protection against extending the reach of this ability to invade privacy through internet service providers and make sure that the disclosure of information is only guided by the demand that there be reasonable, that they believe on reasonable grounds that it's necessary. So I hope that this amendment, PV8, I hope that you'll find it acceptable.
Merci. Avant de me tourner vers vous, Monsieur.
Thank you. Before giving you the floor, Mr. Caputo, I would like to inform you that if this amendment is carried, amendments CPC 27 and NDP 9 cannot be moved because there is a line conflict. Mr. Caputo.
Thank you. With the greatest of respect to the leader of the Green Party, I prefer the wording in CPC 27. I don't take issue with the rationale behind it, but that is the only reason why I'll be voting against this. Thank you.
Merci, Monsieur le député Caputo.
Thank you, Mr. Caputo. Are there any other comments?
Non, nous allons maintenant procéder à décider si PV8 est adopté. Est-ce que PV8 est adopté?
Is PV8 carried? No. PV8 is therefore defeated on division. CPC 27. Is CPC 27 moved?
Y a-t-il des interventions sur CPC 27?
Yes. Any comments on CPC 27?
Monsieur le député Ramsey?
Mr. Ramsey. CPC 27. The sharing of non-confidential simple information would be subjected to a proportionality measure that is unusual, and it opens itself up to problems if it is difficult to establish that proportionality in regular operations, and perhaps Mr. Arbour can comment on that.
Merci, Monsieur le Président, pour la question.
Thank you for the question, Mr. Chair.
Oui, c'est l'amendement.
In regards to this amendment, it would add criteria for information sharing, even if the information were not confidential. That would add an extra layer of consideration to government activities that already exist. There are routine information sharing activities to check compliance with an order or with a regulation, and that information is not confidential. So this amendment would introduce an extra level of confusion when it comes to routine activities for example, checking compliance or other routine activities. Microphone, please.
Merci.
Thank you. Is CPC 27 carried?
Non, nous allons procéder par vote de...
No, we will proceed to a recorded vote. Mr. Clerk, interpretation will resume after the vote. This is a vote on amendment CPC 27.
Mr. Danko.
Nay.
Mr. Pulowski.
Against.
Madame Auguste.
Contre.
Mr. Caputo.
For.
Mr. Lloyd.
In favor.
Ms. Kirkland.
Pour.
Mr. Au.
In favor.
Madame de Bellefeuille.
Pour.
Yeas pour 5, nays contre 4.
Merci, Monsieur le Greffier.
Thank you, Mr. Clerk. Amendment CPC 27 is therefore carried. Amendment NDP 9. Oh, I went too quickly. So NDP 9 being in a line conflict with the amendment that we just adopted is out of order.
28.
CPC 28. Is this amendment moved? Mr. Caputo.
Yes, I will move CPC 28, and if I may please ask the officials whether there is an issue with any overlap with this amendment given the passage of CPC 27. I'd like to know that before I proceed any further, please.
Thank you, Mr. Chair, for the question. There does indeed appear to be a degree of overlap or duplication, since CPC 27 applies generally and 28 focuses on personal or de-identified information. CPC 28 also introduces a concept of collective belief on behalf of the government entities involved, which is also not something that I've encountered before, and could create some confusion of how do you determine like a group agreement on the question at hand.
Okay, given the overlap, I would seek a unanimous consent to withdraw, and we can move on to NDP 10. Thank you.
Is there unanimous consent to withdraw the amendment? Yes, there is. Thank you. Moving to NDP 10, which is deemed to be moved. Madame Kwan.
Thank you very much, Mr. Chair. The rationale behind this amendment is that civil society groups and privacy advocates are concerned that the information collected under Bill C-8 could be used to achieve objectives that are unrelated to cybersecurity, including intelligence and surveillance activities. This amendment would introduce a interpretive clause to prevent such misuse of information collected under the bill by limiting its use to, quote, purposes related to cybersecurity and information assurances, end quote. Thank you, Mr. Chair.
Merci, Madame la députée.
Thank you, Ms. Kwan. Are there any comments on NDP 10? Mr. Ramsey. Essentially, to put limits on cybersecurity, well, we can think of circumstances that don't have to do with cybersecurity when it comes to extreme weather events, for example. So this might be a notion that would merely add more confusion to the bill. We therefore consider that it is not necessary. Perhaps we could ask Mr. Arbour's opinion.
Merci, Monsieur le.
Thank you for the question, Mr. Chair. To change things up, I'll answer in English.
So there are already a set of scoping requirements that prevents even the collection of information for law enforcement or investigatory purposes or broader national security surveillance issues. This is done at the overall scoping of the law itself, but also in each individual provisions. And so information can only be collected if it's necessary, not just relevant now, to the order-making authorities. So it's scoped a number of different ways. In terms of the challenges with this provision of limiting it to cybersecurity considerations, Part 1 deals with a range of risks to the telecommunication system, of which many of them are not specifically cybersecurity. With climate change, we've seen a 5-fold increase in catastrophic damages to infrastructure as reported by the Insurance Bureau of Canada. And so the information and activities that are contemplated are not strictly limited to cybersecurity. There are other provisions that already provide guardrails, and there are further amendments that are being adopted or contemplated specifically targeting personal information that the committee has either already adopted or will be contemplating moving forward. Thank you.
Thank you. And before we move to whether the amendment is adopted or not, let me signal that if this is moved, and therefore CPC 29 will not be movable, given that they are identical. Is NDP 10 adopted? Nous allons procéder par appel nominal, s'il vous plaît, Monsieur le Greffier.
We'll have a recorded vote, please, Mr. Chair.
Merci, Monsieur le Président.
Thank you, Mr. Chair. The vote is on Amendment NDP 10. Interpretation will resume after the vote.
Monsieur Danko?
Nay.
Mr. Pawlowski?
Against.
Madame Auguste?
Contre.
Mr. Caputo?
For.
Mr. Lloyd?
In favor.
Ms. Kirkland?
For.
Mr. Au?
Yes.
Madame de Bellefeuille?
Non.
Yeas pour 4, nays contre 5.
Thank you.
Yeas 5, nays 4.
Defeated. Moving to CPC 30. Is CPC 30 moved?
No, yes, so CPC 29, I will not move CPC 29 because it's identical and we know how that's going to go. So yes, I will move CPC 30, please.
Thank you. Any intervention on CPC 30, Ms. Ramsey?
We will vote yes.
Okay, thank you, Mr. Ramsey. Madame de Bellefeuille, ça va? Très bien. Alors, est-ce que CPC...
Very well. Is CPC 30 carried? Carried on division, which brings us to Amendment CPC 31. However, CPC 31 has a line conflict with CPC 30 and therefore is not in order. which brings us to NDP 11.
Est-ce que le NDP 11?
NDP 11 is deemed moved. Ms. Kwan.
Thank you very much, Mr. Chair. Similar to NDP 6, with this amendment, it introduces safeguards on the government's ability to share sensitive information with other countries and foreign or international organizations. It requires that the data retention and deletion clauses be included in agreements and MOUs entered into with foreign agencies. It also requires that these retention periods will be communicated to the telecommunications providers and that personal and de-identified information are deemed confidential for the purposes of Section 15.7, Mr. Chair.
Thank you, Madam Kwan. Any intervention on the NDP 11? Mr. Ramsey?
On ne peut pas voter en faveur.
We are unable to vote in favor of that amendment. Which, in fact, would require that the government disclose agreements with foreign companies and telecommunications. It would make it necessary for us to disclose information on confidential information with international entities in communications. Thank you, Mr. Ramsey. Other comments on NDP 11?
MP Caputo?
Sorry, thank you, Mr. Chair. I'm just trying, if the officials can help me out, please. I'm just trying to keep everything straight, and I want to make sure that we don't have any sort of conflict between sub 3 of NDP 11 and CPC 30. It seems to me like they are essentially tackling the same thing. If the officials could please weigh in on that.
Thank you, Mr. Chair, for the question. Indeed, there is quite a bit of overlap between NDP 11 and CPC 30 to the degree that it would likely be interpreted as a drafting error down the road, given how similar it is. So that creates an issue. There is the one new element in NDP 11 that's not in CPC 30 is a requirement that the government disclose to any telecom service provider that it has entered into an agreement with another state. And so that speaks to the concerns that Mr. Ramsey was outlining about requiring the government to keep potential dozens of telecom service providers up to speed with basic international relations, which would be problematic. Given that 15.7 already prohibits the government from sharing even confidential information, that personally strikes me as quite a bit of cost to the government's conduct of international relations without material benefit from a privacy standpoint, in addition to, indeed, the duplication with CPC 30.
Okay, thank you. I mean, what I would prefer to do, and I would leave it to Ms. Kwan to gauge her feelings on this. But my thought is to, because of the overlap in the officials' comments, I would be prepared to vote in favor of sub 4, but then that would require deletion of sub 3 in the motion.
Thank you, MP Caputo. Any other intervention? Is NDP 11 adopted? No. Alors, NDP
No.
rejected on division. CPC 32. Is CPC 32 moved?
Yes, please, Mr. Chair. Thank you.
CPC 32 is therefore moved. Any intervention on CPC 32? Madame de Bellefeuille?
Ms. de Bellefeuille. In reading CPC 32, it seems to me that it is similar to BQ 7. Do you have any notes on that, Mr. Chair? I just wish to clarify whether it's identical or similar. Excellent question. I will suspend for 1 minute. Don't go away. I'll make sure we get the right answer.
Recommençons. D'un point de vue procédure, l'amendement est
We're resuming. From a procedural standpoint, the amendment is in order, so we will now turn to the experts from the department to answer Ms. de Bellefeuille's question in regard to the two amendments.
Je pense que c'est BQ6.
I think it's BQ6, 7, BQ7.
Ah, pardon, bon, BQ7.
Merci, Monsieur le Président.
Thank you for the question, Mr. Chair. In fact, I believe there is more than one conflict. For example, from a policy standpoint, the committee has carried BQ5, which would make it necessary for all personal information to be considered automatically confidential. But this amendment, on the other hand, indicates a way that the government would have to manage personal information which would not be confidential. And that is a conflict in the Act specifically, because all personal information would be considered confidential according to BQ5. Then there are other conflicts with the Bloc Québécois amendments concerning management of information and the communication of that information. So in my opinion, there are a number of conflicts, but overall, I believe that the committee agrees that the principles, with the principles in general, but this CPC amendment would create a conflict in the wording of the bill.
Microphone, Madame de Bellefeuille.
Microphone, please. I'm not sure if I understand your explanation, because now you're telling me that CPC 32 would be in conflict with BQ5, but I was asking you about BQ7, so I would say I'm a bit confused.
Oui.
Yes. Thank you, Mr. Chair, for the question. So with BQ5, so there is a conflict to a certain extent in terms of concept, but in writing CPC 32, the Conservatives are talking about a concept of personal information that is not confidential. However, according to BQ5, all information that is not identified by the telecommunications service provider as being confidential would be automatically considered confidential. So it is impossible to have personal information that is not confidential.
Si, par exemple,
If, for example, in light of the explanation you've given me, if we were to accept CPC 32, given that we already carried BQ5, it would mean that we would have a problem? Yes, that's correct. I think that I understand the committee's intent, but there would be a conflict in drafting the text specifically.
Merci, Madame la députée.
Thank you, Ms. de Bellefeuille. Are there any other comments? Seeing none. Is CPC 32 carried? I'm looking around the table and I see that it is defeated on division, which brings us to PV 9, which is deemed moved. Ms. May.
This is the longest amendment of the package that I've prepared, and it's because the gap is large and the risk is large. I know that although there are no line conflicts, but I appreciate that, as in other cases, a number of us are trying to get at the same end from different places. Now, much further in the package, Bloc Québécois 12 and Conservative 45 try to get at the same policy objective, but and the language here is carefully worked out based on briefs that were received by the committee, particularly by the Canadian Civil Liberties Association and Citizen Lab. The concern, as we know, and I think in this we disagree with some of the advice from our experts here at the table, but the expansion of the communication security and establishment's ability to access personal data is made possible under C8. It is concerning. It is not sufficiently restricted how personal data obtained through these provisions can be used for purposes unrelated to cybersecurity. It's been mentioned before, a concern about how they can be used in foreign intelligence and criminal investigations. It constitutes a significant expansion of the government's ability and capability to investigate these concerns, and the use of personal data obtained through provisions in Bill C8 must be strictly limited to only cybersecurity provisions. So it's for that reason that, as you look at PV 9, the Green Party 9th Amendment, that it is long because it's setting out in detail, in a workable format, how to ensure the legislation functions and is clear. To say that communication security establishment, I won't read the whole thing, Mr. Chair, obviously, but shall not carry out any activity under this Act in relation to security of Canadian telecommunications, except in accordance with the authorization issued under subsection 2, which is also new and in this amendment, an authorization to the communication security establishment that authorizes it to carry out an activity specified in the authorization only if the minister believes on reasonable grounds the activity is reasonable and proportionate, and so on. So it's a very strong set of guardrails. It doesn't get in the way of cybersecurity, but it does ensure that the door that's opened in C8, it doesn't lead to abuse of personal information and doesn't lead to abuses that Canadians are very, and so many witnesses have raised to this committee. So I haven't, in case anyone's keeping track, none of my amendments have passed yet, so I'll go for the sympathy vote and just see if we can get this one in. Thank you, Mr. Chair.
Thank you, Madame May. I turn to MP Caputo first.
Thank you. If the officials, I'm mindful of the fact this is a tough question given the length of Green Party Amendment 9, but Ms. May pointed out the complementary nature, or just the potential overlap is probably a better term, of CPC, I believe it is 45, and Green Amendment 9. I'm wondering if the officials could, at the end of the day, I just want to get the best language. So I don't know if the officials can opine on that. That's probably for the committee to decide. But whether or not they can do a quick compare and contrast, and whether whether there are implications for interpretation in one that might not be in the other. And I'm sorry, if you need a couple of minutes, I apologize. Please just let us know.
Yes. Okay, so we'll suspend for a few minutes so that we get the most accurate answer. was useful to. I'm going to call it for order, which I rarely do because of the disciplined nature of the MPs around the room. I see the Liberal MPs being less disciplined than the others, so I will call them to order in particular. And I know I'm not making friends by doing that. But that short pause, I think, gave a little time to the experts on the other side of the room to reflect upon the important question that was raised. Any input into this?
Thank you, Mr. Chair, for the question. So we looked at a crosswalk between this and the amendments that were mentioned. Given that they apply to different parts, and fundamentally to different acts at the end of the day, the Telecommunications Act and the Critical Cyber Systems Protection Act, it's a pretty complex piece of drafting, but we don't think that there is a conflict there. There are many other substantial problems with this amendment, but in terms of a conflict with the specific ones that you asked about, we don't think so.
Oh, okay. Thank you. I appreciate that, and I know these things don't solve themselves, and I know that it takes a while to look it over. So I thank you for your timely response. You did mention some issues with this. Now, we may not agree on these, but if you're prepared to lay them out, and that will inform how I vote, please.
Thank you, Mr. Chair, for the question. So the CSE already participates in a range of voluntary activities with ISED and with the telecommunications sector regarding the sharing of threat analysis and understanding best practices for how they can secure their network. So my colleague here, his team oversees a private sector government working group that includes CSE and public safety and that sort of thing. So there's already a range of activities that do exist. CSE is still bound by the guardrails under the CSE Act in terms of how it operates, and there's a set of oversight mechanisms that govern CSE as it is. This amendment seems to CSE does not have any regulatory powers or investigatory powers or anything under the Telecommunications Act currently or under C8, but this proposes to have the Minister of Industry take on a new oversight role of designating CSE activities in implementing certain aspects of the Act and governing certain aspects of sharing information that raise quite a few substantial practical and operational questions for us. I also note that the committee has already adopted a range of existing protections in terms of the sharing of information already, and specifically on personal information that, in my opinion, are much better targeted. If there are broader questions about the oversight of the CSE and how that would work, in my opinion, the CSE Act would be the better venue for dealing with that, and trying to work that into the Telecommunications Act and a new oversight function for the Minister of Industry seems quite complex and confusing. Thank you.
MP Caputo.
Thank you, Mr. Chair. For my colleague, Ms. May, I may have missed this. I apologized earlier. Obviously, this is a very nuanced amendment. I'm wondering if she could just tell us about the genesis of this amendment, where it came from. Was it verbatim from somebody or a group, or was this taken together from a number of different recommendations, please?
Question, Frank. It comes from the Canadian Civil Liberties Association in their brief to committee, specifically out of recommendation 5. And in drafting it, we also worked with them in saying, how do we address the concern that's found in recommendation 5, and how do we ensure that the communications security establishment's ability to access this personal data is absolutely nailed down to only those purposes that C8 intends.
That's enough for me to vote in favor for it. Thank you.
Thank you. MP Ramsey?
Écoutez, je veux simplement,
Look, Mr. Chair, I would just like to reiterate what Mr. Arbour said. So modifying or specifying the legal activities of the CSE would be something better carried out if we were to amend the CSE Act instead of redefining the scope of the Telecommunications Act, or in regards to the Minister of Industry, who is not really that related to the specific area, but we will be voting against. Thank you, Mr. Ramsey. This brings us to the question, is PV9 carried?
Refusé, rejeté avec...
Defeated on division, which brings us to BQ7. Is BQ7 moved? Yes. Yes, Mr. Bellefeuille? Yes. So we maintain the tabling of BQ7, which would help us to even better clarify the sharing of information to better respect privacy. And we're basing ourselves on recommendations from the Privacy Commissioner's Office.
Merci, Madame la députée.
Thank you, Ms. de Bellefeuille. Mr. Ramsey? So in the largest part of the amendment, we would be ready to vote for, but we would like to propose a sub-amendment because it seems to us that there is a conflict in the saving of information or deleting of information. It could infringe upon the Privacy Act. So we would like to eliminate the final 8 words of the amendment. So whichever retention period is shorter, which in French is 8 words. Thank you, Mr. Ramsey. So do we have specific enough information to share that with the members of the committee? Yes. And did all committee members understand the sub-amendment? And just in parentheses, we've all understood that if BQ7 were to be carried, CPC 33 could not be moved since it is identical to BQ7. So since we are debating BQ7, we will not be able to debate CPC 33 thereafter. Given that, is there any comment on the sub-amendment? Is the sub-amendment moved by Mr. Ramsey carried?
Le sous-amendement.
Mr. Ramsey's sub-amendment is carried, which brings us to discuss amendment BQ7 as amended. Is BQ7 as amended carried? BQ7 as amended is carried, which brings us to CPC 34, since we skip over CPC 33. Is CPC 34 moved?
If I could just have a quick moment, because my concern is that we are essentially dealing with a conflict between BQ7, which just went forward. If the officials could just confirm that, please. It looks as though we're in a bit of a conflict, though.
So what we just did, as you noted, MP Ramsey, MP Caputo, is to vote on BQ7, which was amended. And having considered BQ7, we need to skip CPC 33, which is identical to BQ7.
No, I'm talking about 34, please.
34, okay, sorry.
I think that 34 is almost identical except for sub 2. I just want to...
There is a redundancy, indeed, with BQ7, but it's not identical.
It's not identical, but it's close enough. I think we would be getting into dangerous territory. and the Liberal sub-amendment would have to move a sub-amendment, and we'd be dealing with conflicting legislation there. If I could ask the officials, I mean, I think sub 2 is very clear. Just out of caution, does that conflict with anything that we have passed so far?
Thank you, Mr. Chair, for the question. So just to make sure I'm referring to the right area, so we're talking about CPC 34 sub 2 in the case where the information was provided by
Yes.
Yeah, okay. So, the issue that I'm grappling with sub 2 is that it would require us to notify a telecommunications service provider about the disposal of personal information. So the concern is less a conflict in law than we would have to basically apologies for being slow here. So I think that certainly whether there's an actual legal conflict, there's certainly a policy conflict in terms of how we would try to interpret the spirit of the provisions, because we are required to dispose of the information as soon as it's no longer needed or in accordance with the Privacy Act. But then we're also supposed to communicate with the telecom service provider what we've done, and for us to communicate that, like it almost gets into we'd have to specify the information in question, which involves us, like how would we talk about the personal information without, again, using the personal information in some shape or form? We don't foresee using personal information under these authorities, so it may be moot in practice, but in reality, there does appear to be effectively a conflict here.
Given that, then I won't try to make the legislation any more complicated. If the officials can get one there, and so I won't move that amendment, please.
Thank you, MP Caputo. So not moving CPC 34 brings us to CPC 35, for which, according to my understanding, there may be also a redundancy with BQ7.
I will not be moving that one.
Thank you. So that brings us to CPC 36. Is CPC 36 being moved?
Well, I do note the time, Mr. Chair. I am worried that, hey, I will work however many hours you want me to work. The Liberal colleagues say, I think they have somewhere to be at 5:30. But I will, well, I'll let you have mercy on the Liberal colleagues.
So there is one good news here and one bad news. The good news is that MP Caputo is willing to work all the time and every time. The bad news is that he cannot work alone. So he needs other colleagues. So if I understand well, there would be a motion to adjourn. So is MP de Bellefeuille?
Oui, avant que vous puissiez.
Yes, before you move to adjourn, I would like to thank the interpreters who have done excellent work today and who have allowed me to intervene in real time. I want to thank them because it makes all the difference for us. Thank you very much.
Votre reconnaissance est largement.
I think that your sentiments are shared, and we would also like to thank even more people in this room and elsewhere who work extremely hard. We will thank them another time, and we will be meeting on Thursday on another topic. And, of course, we will continue clause-by-clause consideration after the riding week on March 24th. Thank you.